Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. It's our every fortnight phone call that we do for the community, and we've been doing it for several decades. We are answering the questions to best of our ability and subject to all the disclaimers that you heard while you were logging in. I just want to remind everyone that you can raise your hand if you have a question related to the topic that I'm discussing, and you raise hands by pressing *5 on your phone, and I'll remind you as we go along. So we'll begin first by answering the frequently asked questions, which I believe are the ones people have uppermost in their minds. So let's begin with, first of all, this is a typical question from Ralph. L1B or TN visa for intra-company transferee, advantages and disadvantages. So what Ralph is saying is that I've got the option to do an L1B or a TN visa, which, by the way, is reserved for the citizens of Canada and Mexico. Firstly, to confirm, an intra-company transferee can use TN route, and the answer is yes, sure. Because the TN visa requires a professional level job in the United States, one of the list of the jobs that the two governments have decided upon, Canadian and US, or Mexican and US. You have to fall into one of those categories. The fact that you were employed by a sister company doesn't really matter. TN visa works independent of that. By the way, TN stands for Treaty National, which means the government of two countries have a treaty. How does a strong L1B application look like? Evidence to provide. So L1Bs are typically extremely difficult to prove. They are the easiest ones to prove when you are dealing with a company that has a product, for example, let's say a software, or even a hardware device. We've done both kinds of cases, as well as in other professions. But it works very well when you have a product and the person who's being transferred on L1B has knowledge of the product which is advanced as compared to other engineers in the same company and as compared to engineers in the open market. So we do a combination of the two, advanced and perhaps special knowledge. What does that mean? I can give you an example. So let's say that we have a cybersecurity product, something that does endpoint protection sitting on the server. It does endpoint protection. Now, the architecture of a product that can do this at an enterprise level is, of course, quite complex, right? So that means in order for you to qualify for L1B, you would have to be one of the initial architects or one of the architects that has been doing this for at least 1 year, so that we can say that you've got 1 year's experience as a specialized knowledge employee. Okay, so L1B can be quite difficult to obtain. Does it have any advantage over TN? Yes. The problem with TN is that you cannot apply for a green card. You can, but if you need an extension or if you are traveling out and the fact that you have applied for a green card comes up, the TN entry can be denied. So the way I look at it is, maybe you could start on a TN, and if somewhere along the line it becomes a difficult problem and you get stuck outside USA, you could then convert to an L1B if the ultimate aim is to get a green card in the United States. So this would be my main question. You are India, China born, work for a multinational corporation and provide technical services to clients for ERP products. We've actually won a few cases where even though the company did not have a product, they had a mixture of expertise which was very difficult to find. So I'll give you an example. One of the cases, I'm trying to remember all the details, but I do remember that they created appliances, but their appliances were based upon some open source technologies as well as hardware. One of the chip they had they used to get manufactured based upon their customization, but rest of the material was basically either open source or off the shelf. But we were able to procure an L1B for them, an L1B for them. So just one advantage and disadvantage which I mentioned. The advantage of TN is it's very quick. If getting a green card is not an issue, TN is a great way to go. I love TN visas because you get them right at the airport. You don't have to go through a lengthy processing or right at the land border. And also they can be extended on a 3-year basis forever. There is really no limit on them. L1B has a limit of 5 years, after which you have to go outside the United States for 1 year. If you have a follow-up question on what I've talked about, press *5. So what I'm suggesting is you could probably try a mix and match. If you want to do a green card, come in on an L1B. If you're not sure, come in on a TN. Somewhere along the line, you could talk to your lawyers about the green card. Okay, since there are no follow-up questions on this issue, I'll go on to the next question. This is also quite frequently asked. This is a question about a STEM designated MBA. Is it easier to get an H-1B visa? And the answer is yes. One of the most idiotic propositions made by the government is this: MBA is not a professional. MBA is not a specialty occupation. Why? Because MBA is too generic. Personally, I think planning and running a business is not generic. It is actually quite a specialized degree. But so far, courts have not gone against the government in this. So if you have an MBA in marketing, so you could probably get an H-1B visa in marketing. Probably. There are issues there also. If you have an H-1B in, an MBA in technology, in management information systems, information technology management, it might be a little easier. So it depends. I'm trying to see if I can see your screenshots. I have to be logged in, and I'm using somebody else's computer. Okay, so I don't really know what this says. I came on a marketing, it is said that there can be a lot of issues. Yeah, so marketing also can be done, but it's not as easy as a STEM-based MBA. So overall, if there is a choice and you are interested in the field, you should definitely go for an MBA with the technology major. Okay. *5 if you have a follow-up question and you are here, press *5. Anybody has a follow-up question on a STEM designated MBA? Okay. Another advantage is that you should be able to get the STEM extension also on top of your 1-year OPT. Okay. So that also helps. Now this next one is quite complicated. Okay. This is about the interplay. First of all, the first part is about, you know what, I forgot to check whether you can hear me or not. Let me just make sure. One second.
The conference is now in conversation mode.
Hey guys, you can all hear me okay, right?
Yes, sir, I can hear you.
Okay, excellent. Thank you.
The conference is now in presentation mode.
Okay, so we have a very complicated set of issues here, which is how does CSPA, Child Status Protection Act, relate with downgrading from EB3 to EB2, upgrading, etc. And the second part of these questions is, what should we do with children, our daughters and our sons who are turning 21? We are here on H1, they used to be on H4. Once they turn 21, they can no longer be on H4. What do we do with these people? These legal dreamers, so-called legal dreamers. So let's first look at the Child Status Protection Act. Child Status Protection Act protects children who are turning 21 and keeps their age below 21 artificially through certain computations. I'll talk about those computations in 1 second. That way, the children have the advantage of inheriting their parents' green card. So if you are getting a green card through employment and your son is turning 21, if they turn 21, they can't get your green card. You have to apply for their green card separately when you get your green card, and that can take quite a lot of time. And it doesn't work if the son or daughter is married. Okay. So Child Status Protection Act protects children despite them turning 21 by making some computations. I'm not going to get into all the computations. It's a fairly lengthy, complicated piece of legislation which has become unnecessarily difficult to understand, but that's the way it is. Especially it becomes problematic when you have upgrade and downgrade. So before I talk about upgrades and downgrades of EB3, EB2, let's talk about something which has again been a problem for a lot of people to understand, which is when you get the visa bulletin, you can file an I-485 if your dates for filing are current, even though final action dates are not current. So if you don't already know that, just let me know and I'll cover a different portion for it. I'll explain to you how that works. But you can file your 485 the moment your dates for filing are current if you're on 485. Okay. However, Child Status Protection Act only protects once the final action dates become current. So what does that mean? Well, let's say I applied for my 485 and my son was 20 years and 6 months old. I'm not going to take the computation of how long was the I-140 pending. Let's say I did the I-140 premium processing. It was approved in 3 days. So let's keep that out of the picture. That's a totally different discussion. So my son was 20 years and 6 months old when our dates for filing became current. We filed the whole family's 485. Unless the final action dates become current within the next 6 months, my son will age out. He will not be able to get a green card through me. So, therefore, final action dates must become current even if they become current for just a day before the child turns 21 according to the CSPA calculations. Okay. Now, what does this do? This creates complications when you're doing upgrade and downgrades. So for example, let's say that my son is protected when I file my I-485 under EB2 because the dates for final action became current. But if I convert to EB3, he will not be protected unless the dates for final action or final action dates are current. So that's something to keep in mind. If you change your tracks, you have to make sure that proper computations are done to make sure that your children are protected by the Child Status Protection Act. Okay. So now that's one way to do that. That's something to remember. Remember, again, I'll summarize that Child Status Protection Act protects children who have turned 21 or will turn 21 during the pendency of the green card by artificially computing their age in a certain way. There are several things that go into that computation, but for our purposes, the most important thing to remember is we don't care if the dates for filing were current, the children are not protected unless before they turn 21 according to CSPA computations, their dates for final action or final action dates become current. Once they become current, they are protected. So if you go from EB2 to EB3 or EB3 to EB2, you've got to keep this in mind. Okay. Now comes the second part of the question. I'm going to take the specific questions that many people have posted. All of them were pretty much on the same angles. So the second thing is, what do we do with our children who are going to turn 21 and my dates are not current, anywhere near current? Okay. They are a part of my green card process, but what do I do? And the answer is most of these children, most of these young people can be put in the F1 category if they are in school, so they can just go to student status. In most of these cases, despite them being actively involved in your green card process as dependents, government has been giving them F1 approvals. So therefore, that would be your best option. The problem is Sometimes you'll get a request for evidence from the government when you apply for a change of status from H4 to F1 saying, well, where is your home in India or China or whichever country you are from? Are you planning to return to that home? You have to respond to that. I would say take the help of a lawyer. That may not be something you can handle yourself. Take the help of a lawyer and explain the circumstances. Explain to the government exactly what's going on. I am yet to see a denial of an F1, and even F1 visas. Every student that I've talked with in this circumstance, they've been able to procure either a change of status or an F1 visa. Also remember, when they go from H4 to F1, they can continue going to school while the F1 change of status is pending. So to summarize, F1 could be a viable option because the government, out of the goodness of its heart, so far has not been making a big stink about having non-immigrant intent and not having a green card process going even as a dependent of an employment-based case. Okay. So far what I have discussed, I'm going to discuss the questions that people have posted, but so far, if there's any question about what I have discussed, either on the final action dates for filing, or how to maintain status for children, press *5 on your phone. No new questions. Any question related to what I discussed, press *5. Okay, so now let's look at the, oh, that's nice. You are very welcome, sir. I would like to get your valuable opinion. Best option, son is on H4, 19 years, 4 months, second year undergrad at Berkeley. Priority date is November 24. Approved I-140 on EB2. Last October, we applied for AOSS downgrade with the concurrent filing of I-140. I-140 is not approved yet. It is in the RFE stage. My son received EAD and advanced parole valid for 2 years. We were advised not to use the EAD as interfiling might not be possible if EB2 advances faster. Well, I have only one comment to that. I would like to know the reason for somebody to say that. You see, if I'm maintaining my F1 status, why can't I do an interfiling? So if your son continues to maintain his F1 status, I don't think it should be a problem to interfile. So I've already answered your question that your petition must reach the final action dates at least once before your son turns 21. Okay. And in your case, if your son reaches 20, or the final action dates become current under EB2 before he turns 21, then go with that. Otherwise, stick to one track because that may be your best option. But your lawyers can help you decide comparing the two categories. I disagree about the use of the EAD, etc. Because you can always revert back. I think the main problem, why people are concerned about, I'm not sure what the legal grounds are. Some of my other colleagues have mentioned it too, and I've never been given a good answer. I think the concern is this. If you use your EAD, you are no longer in F1 or H4 status or H1B status. But you can always restore the status if you go outside USA and come back using that visa, F1 visa, H4 visa, H1B visa. So the use of EAD is a temporary interruption on your H1B. It is not a permanent interruption. It can be reverted. And after that, you can come back and request a change of categories or interfiling. You see my point? So their only concern is that you fall out of your status. And at that point, if you do interfiling, government can take an objection. But I think that can be easily reversed. Something to consider. I'm not sure exactly what the circumstances are. Okay. So as far as the dual intent question is concerned, I've already dealt with it. I think the government has so far been benevolent. We've been getting approvals. We've been getting even F1 visas from consulates. So I hope that it continues the way it is. Today I was reading in the Economic Times that 91% approval rate for H1Bs this year, which is remarkable. It looks like this government has restored some of the balance that was turned topsy-turvy by the previous administration. I can only hope that they continue to maintain the same benevolent attitude towards these young legal dreamers. Star 5, if you have a follow-up question on what I have discussed so far, press star 5. Okay, next one is, it's a series of the same questions. This one is from California. So there's a call from somebody in California. Yeah, California, go ahead, please. Area code 408.
Yes, hi, Khanna.
Good afternoon, sir.
Yeah, hi. This is based on the previous conversation you had.
Right.
So I filed for my daughter's green card based on the EB3 dates becoming current.
Right.
Now, let's say she turns 21. So she's currently protected, no issues there.
Okay.
But let's say she turns 21, and subsequently, if the EB2 dates become current, are you saying that we may not be able to do an interfile?
No, let's just examine your daughter's situation. Okay. So first of all, even if you have filed the 485, your daughter is not protected. Okay. Because if you filed the 485 based upon dates for filing being current, that's not what triggers CSPA protection. CSPA protection is triggered by final action dates.
Yeah, our final action dates were current.
Okay, so once she has been protected under EB3 category, now if you file under EB2 category and the final action dates are not current, her age will have to be computed. She will not be automatically protected just because she was protected under EB3. My understanding is the protection does not transfer across categories. That's been the problem.
Okay.
Okay.
Got it.
Anything else?
Okay. Thank you.
You're welcome. Good luck.
No, thank you.
Good luck, sir.
Yeah.
All right. So let's go on to the next question. So this one, these are multiple questions by different people. I combined them into one because they were really all one discussion. Downgrades for family approved before son aged out. Will filing for EB2 jeopardize son's green card EAD? So I filed for EB3 downgrade along with my wife, received the EAD card. Final action date becomes current before my son's turned 21. Great. My son also applied for change of status to F1. It's still pending. I'm in H1B. The I-94 of my wife expired. I have filed for extension. I'm wondering if EB2 final action dates became current, I'll be qualified to file. No, but your son will lose his protection. That's the way I understand the law. But there are a lot of moving parts here. Double check closer to when the dates become current. Make sure that government still holds the same policy position, which I think is kind of unreasonable, but that's the way they interpret it. Because if you change tracks, he may not be protected. Star 5, if you have a follow-up question. Star 5. So you might be stuck with the EB3 category. Next is, again, the same series of questions. EB3 approved, GCEAD pending. Will aging out child's application for SSN create an issue? I don't see any problem with applying for a social security number. I do not believe that's a problem. As far as I know, that's not an issue. Next question, options for aged out son on F1 OPT. Son A aged out could not be included. Currently on F1 OPT. Already filed his I-130, which takes 5 to 6 years. Company is intending to offering him a full-time position. He'll just have a few months remaining on OPT plus another 24 months on STEM. Is it better to... Oh yeah, absolutely. Ask his company to keep applying for H1B each year. Because under H1B, he never has to worry about dual intent. It is a dual intent visa. You cannot defer your H1B start date to the end of your STEM OPT 2 years down the line. You have to utilize the lottery in the same fiscal year. Otherwise, you'll be out of the lottery. How early can you apply for OPT extension? Isn't it 180 days? Yeah. I think it's 180 days. You can double check under dhs.studyinthestates or studyinthestates.dhs.gov, just Google study in the states. That brings you to the USCIS official site that deals only with student issues. You should have that information there. I'm pretty sure it's 180 days. *5 if you have a follow-up question on any of what I've discussed on CSPA. *5 if you have a follow-up question. Okay. Another one from California. Yeah, California, go ahead, please.
Yes, thanks, Rajiv again. So that SSN question was mine.
Okay.
So I think the question is, when I applied for my daughter's EAD and GC, I said that please allocate a new SSN. But subsequently, we got her F1 approved, which we had applied last year, December. So my question is, if I now out of the way go and apply for SSN, will that interfere with my previous selection that I made during the EAD application?
You will have to contact the USCIS to make sure that they don't make another request for SSN, although that request should not be granted by the Social Security Administration. But it's a good idea to go through their customer service and let them know that you would like to withdraw that request. They should be able to figure out a solution. Although I don't think it's a real risk. You're not going to get 2 Social Security numbers. Okay.
Okay. All right. Thank you so much.
Good luck.
Bye.
Okay. Now, this is another very interesting question. Do we have to refile PERM or I-140 or I-485 due to corporate restructuring, and talk about successor-in-interest? So, folks, for H-1B, L-1, PERM, all these employment-based petitions, there are certain circumstances under which you have to restart everything and certain other circumstances under which you do not. So I'll give you first the generic idea. There's a doctrine called successor-in-interest. So if company X comes and buys all the stock of company Y, I'll start with the easiest. Company X comes and buys all the stock of company Y. Company Y's employees can continue their green card, L1, H1B, everything undisturbed as long as the jobs remain the same. Same location, same job description, same salary. A few thousand here and there may be not a problem. So the point is that under the successor-in-interest doctrine, some company that has bought another company can step into the shoes of that other company and become successor-in-interest. When you have a successor-in-interest situation, you do not have to redo PERM, but you do have to file the I-140 again if it has not been approved. If the PERM is approved and I-140 is yet to be filed, company gets taken over, you can file with old company's PERM and new company's I-140, and you do have to file tax returns of both companies. Till the date of the takeover, the old company's ability to pay wages must be demonstrated. From the date of the takeover, the new company's ability to pay wages must be determined. So you do not have to file a new PERM if the job remains the same and there's a successor-in-interest situation. That was the main question you had. Okay. So actually there's a little complicated situation. What if a company comes and buys a division of another company? And the answer is it can still be a successor-in-interest if the two divisions or the division itself is separable. So we just assisted in a merger and acquisition for a company that had a very large private employment, a private placement or private employment, but they also were developing a government contracts division. So they sold their private business, but they kept the government contracts business. We were able to establish successorship in interest even where there was just one division being bought. But the reason it succeeded was they were separable. Their taxes, not the taxes, their finances were separate. Their books were maintained separately. the private division as well as the government contracts division maintained separate finances. So we were able to very easily show successor in interest. Okay. So yeah, I think this is what you are asking. Any follow-up questions, press *5. Press *5 if you have a follow-up question. Okay. Then we come to the next. I don't think we have any more frequently asked questions, but we have the regular questions. So let's go into those. The first one is TN denial at the Canadian border. So it was denied twice. Now I'm planning to do a pre-flight inspection. Can I change my mode of travel and port of entry as Toronto, or will that cause an issue? So your question is, if I have been denied TN and now I try to enter through a different port, can that cause a problem? I don't know the answer to that question. It is entirely whatever the NAFTA officer, used to be called NAFTA officer, whatever the treaty officer says or feels about the case, they will have some of the information on the computers. They can see why you were denied. But changing a port just to take a chance with a different officer may not work. But if you have a genuine need to travel through Toronto, whatever that need is, you should be okay. So bottom line, hard to say, but if there's a genuine reason to try somewhere else or go through another border, it should be okay. In the second denial, they have taken your sworn statement from at the port of entry. It was filed as a management consultant. My role is hands-on technical. Can I appeal that sworn statement that wasn't taken in a great state of mind? Well, first of all, let's start with the red flags. Management consultant is always a red flag occupation. So whenever we prepare a TN case for a management consultant, we are aware this is going to be closely examined. Number one. Number two, a sworn statement is a sworn statement. Unless you were under the influence of drugs or some prescription medications that made your mental state unreliable, I think to say that you were stressed out and you said something you shouldn't have may not be sufficient. Okay, but you can try. Anything is possible. There's no appeal, but you can bring it up for supervisory review at the border. Another thing sometimes that could work is to try to get an approval at the USCIS level where these issues can be raised and put to rest. But the same issues can still come up at the border when you try to enter, even if you have an USCIS approval. *5, if you have a follow-up question, Pooja. *5. Okay. Let's go on to the next frequently asked question. The next regular question. So if there's a typographical error in your form I-129, which you discovered just before visa stamping, and this was a mistake made by your employer, you will have to file. First of all, the employer's lawyer should reach out to the USCIS, find out if there's an easy way to correct this. There probably isn't. Then get a letter from the lawyer saying that they are reaching out, and maybe even refile the form I-129 and get that corrected. Now, if you are trying all these things, and in the meantime your visa appointment comes up, just take evidence that you are trying to get this corrected, your employer is trying to get this corrected, and I think you should be given the visa. That's what I think. Now, if you have a choice of waiting to go for visa before only after this gets taken care of, that's what I would do. I would want to have the date of birth corrected before I go for visa stamping. But if the stamping date is already here, bring evidence to the interview of all the efforts that the employer's lawyers are making to correct the situation. That might work. *5, if you have a follow-up question on this. *5. Next question is issues regarding working simultaneously for a US company and a separate home country company while outside the US. So he knows that Ralph knows that he cannot work from USA for another country, a company in another country. So the question is, can I take up work and earn from my home country parallelly when outside USA? I don't understand that question. If I'm in but if I have a work visa in US and I travel outside USA while continue working from a US firm, can I take up work and earn from my home country parallelly when outside USA? I think so. Okay, I got it. So let's say I have an H-1B visa. I'm working in the US. Then I take a month break from my US work, and I'm still doing the US job, but I'm doing it from, let's say, Toronto, Ontario. Can I also work for a company locally in Toronto, Ontario? Absolutely. I don't see any problem with that. Okay. So, yeah, on H-1B or TN, either one of those, I think that should be fine. *5 if you have a follow-up question on this. *5. Press *5 on your phone. Okay. This one is from, Canada. Okay. Yeah, Canada, go ahead, please.
Hi, sir. I have a question on the previous one. This is Pooja. So my petition was approved, TN1 visa through I-129 premium processing.
Right.
And my lawyer mentioned on the form that the land port of entry details, but I want to do the pre-flight inspection. So is it fine, or should I need to raise a form under I-824?
As far as I know, that should not be a problem. But here is what you can do, Poojaji. Give a call to the Customs and Border Protection. This is one agency that actually answers the phones. So you can talk to them. Even at the place where you're going to land by air, you can say, is this going to be a problem because my plans have changed?
Okay. All right.
Yeah,
I'll do that. Thank you, sir.
I don't think it's going to be a problem. Good luck.
Thank you.
You're welcome. Okay, so so we don't have any question on that, I guess. Let's go on. Separate company. Interfiling, refiling. This is a long one. Guys, don't give me these fact patterns. Not even sure I can read through all of this. I'll try, but this is a lot of information. Just within days, few folks waited close to 10 years. Should have filed through EB2 and EB3 lanes. Current company already filed EB2 I-140. Applied for downgrade. Okay, so really your question is this: can I take up a senior manager position with another company? And the answer is, if you are covered by AC-21, your I-140 is approved and 485 has been pending 180 days, you can. Okay. Does one's H-1B have to be active for at least 6 months before I could refile a new 485? No, it does not. If I choose to refile, again, I don't remember your entire fact pattern. It's too long for me to keep in mind in the time that I have. If I choose to refile, will it reset my AC-21 portability period again? As far as I know, it would. But hang on. If you are covered by AC-21 portability, 180 days are already over, and you change jobs using supplement J to a same or similar position, that doesn't reset your AC-21 portability period. And you can use your, well, I think you need, look, Raj, these are questions that require some attention and time, more than I can give here. So, yeah, this is, I'm not going to be able to cover these questions. Sorry, too many of them and too bound to your own facts. Bottom line, you can change based upon AC-21 portability. Once you change, the jobs have to be same or similar. That's the important part. and there's no question of resetting the portability time. You can do AC-21 portability more than once. So let's say you were filed as a technical person, but then you are getting a job as a delivery manager, software delivery manager. You do AC-21 portability. Then you get a job as a CTO. You can do another AC-21 portability. All that is perfectly legal. And there is no cooling off period for a 6-month period before you can file a new 485. Okay, so I'm not going to be able to cover the rest of them. Sorry. Too much information, too little time. Documents required to sponsor parents. What documents are required to file for my parents? Mother is 79, father is 82, born in India, coming on, they don't have a marriage certificate, birth certificate. So for marriage certificate, just a couple of affidavits from people who attended the marriage. And they will need their individual birth certificates. If they don't have that, it's a good idea to get a letter from the municipal corporation or the taluka, if they were in a village, that there is no record of their birth. At that point, you can get affidavits from 2 people who were alive when that particular parent was born. Along with that, you will have things like your Aadhaar card, their Aadhaar card or ration card. So all these things combined should be able to prove their date of birth. Okay. Star 5, if you have a follow-up question on this, star 5. Okay. Let's take the last question. Remote work options for Canada permanent resident working in the US on H-1B visa. I'm a Canadian PR India passport holder, currently on H-1B in USA. New US job offer in Detroit Metro sponsoring H-1B. Is there any issue for maintaining H-1B status if I live in Windsor, Ontario in Canada and commute to work? Yeah, this is done all the time. And there are some implications for maintaining your green card. Make sure you read through the law. The daily commuters have a few twists, but it can be done. I know plenty of people who are doing that. And there is no minimum number of days or weeks, etc. Yeah, you can work from outside USA even. So there is really no requirement that you must be in the United States, as long as you keep getting your salary paid. Also, Google something called intermittent H-1B. Yours is a continuous H-1B, but even if you came to USA, worked for 3 months, left, worked 6 months outside USA, came back for 6 months more, you can use H-1B on an intermittent basis also, as long as it's a genuine use and you're not just, playing cute games with the government. Okay. Star 5, if you have a follow-up question. Okay, we still have about 15 minutes. Anyone has any question, press star 5. Anyone has any question, press star 5. Okay, I have 1 question only, 2, 3 questions, 4 questions, 5 questions. Okay, let's start with whatever pulls up first. Area code 732, I guess that's New Jersey. 732, go ahead.
Hi, Rajiv sir. So we are a company who are looking forward to hire an H-1B employee. This person is going to be on a time H-1 transfer. But I was going through, and the salary we are offering to this person is about $50,000. But I was going through, finding out more information H-1B law, and I found out the information that it has to minimum $60,000, irrelevant of part-time or full-time.
No, that's not true. What is the job? First of all, where is the job located? Which state?
So it's going to be in New Jersey.
Yeah, you're not going to get low salaries. New Jersey has fairly high salaries. Which county in New Jersey?
Middlesex.
Oh yeah, Middlesex salaries are not. They come under New York, Newark, Jersey City. And is it a software developer?
Right. No, it's going to be, the person is MBA with general administration. The person job is office manager / business analyst.
You're not gonna get an H-1B for that.
So even though you hold the current H-1, I won't be able to transfer?
Not for that job description. Office manager, no.
Even the business analyst would not work.
Business analyst is basically a systems analyst, and there have been plenty of cases denied under systems analysis because government comes back and says, well, these are not professional jobs. You don't require a degree in a specific subject. And I already mentioned, MBA is not considered to be a professional degree unless you can combine it with experience, etc. So overall, so far from what you've described, it's a tough get. And the salary is too low. 50,000 for New Jersey area for any job is too low.
Okay, even though it's a part-time?
Part-time, how many hours?
20 hours a week.
So if you were to go with computer systems analysts, the minimum hourly salary at level 1 is almost $34 an hour. Level 2 is about $44.50. Level 3 is a little bit over $55 an hour. So generically, that's how it works. Okay.
So I was doing some more research on my side, and the job title which I picked up for this guy was the management analyst. And for the prevailing wages, it came down to that $44.35 with the 3 years of experience this person has. But that equates to the full-time employment of $692,000.
Yeah, you can pay on an hourly basis on H1 too. So, and you have to decide how many hours the person will work and then pay on hourly basis. You can also have a variable scale. That's a dangerous thing to do. Like you could say 20 to 30.5 hours or 20 to 40 hours. But that's something you should discuss with your lawyers, understand what you're doing. But there is a possibility you could do it like that. But remember, government can come and audit, and if the person is actually working full-time and getting paid part-time, you could all be in trouble. Okay.
Got you, sir.
Good luck.
Thank you so much.
You're welcome.
Yeah, thank you.
You're welcome. Area code 571. I guess that's Virginia, right? Who is on 571, guys? Area code 571. Okay. Area code 214. I think that's Texas. Area code 214. Go ahead, please.
Hello, Rajiv.
Hello.
My name is Rahul. Here's my question. Can you hear me?
I can hear you, yes.
Hello?
I can hear you fine. I can hear you.
Okay, perfect. Thank you.
Yeah.
Perfect. I'm in a situation moving from company A to B. So company A is a startup company and expected to notify USCIS about the last working day on H1 as 12/27. And the transfer petition to the new employer is expected to happen after the New Year holidays. That is around the 10th of January.
Okay.
In this situation, will it create any kind of gap or RFP questions by USCIS moving between the company A to B with a gap?
Company A is withdrawing your case when, did you say?
Expected to happen by 12/27. That is next week, Monday.
Okay. And the new job starts when?
New jobs expected to happen after the holidays. That is around the 10th of January.
When does your I-94 expire?
Oh, I-94 expires by February 2023.
So then you have a grace period, right? So there's no problem. You have a 60-day grace period.
Okay.
All right.
So it won't create any kind of RFP
No,
question.
I don't see that as a problem. All right.
Oh, okay. Thank you, sir.
Good luck, sir. California, 408. Go ahead.
Yes. Hi, Khanna. Just wanted to confirm on the successor-of-interest discussion that we had.
Go ahead.
My situation is 485 is already filed. I-140 approved. Everything is done.
Okay. Can I stop you for 1 second? Can I stop you, sir? 1 second. Was your 485 filed more than 180 days ago?
Yeah.
Okay. Then you do have AC-21 portability. Instead of doing a successor in interest I-140, you can just do a supplement JAC-21. You do not need to start your green card all over again. That's not necessary.
Okay. All right. That's all I wanted to confirm.
Good luck. Absolutely. Okay. Ontario, Canada. Area code 647. Go ahead, please.
Hi, Rajiv ji. So, I have that follow-up question on question number 8.
Okay.
So, can we enter like US for work visa stamping while still having an active employment from home country? Does that cause an issue?
What do you mean?
Like, if I'm going for a different job on TN.
Okay. So, what's happening is that you have an ongoing job in the home country and you're also working in USA on TN.
Yes.
I think that could be problematic. Government could consider that to be, although I don't know if I have a good answer. You can double check with the USCIS customer service. They might be able to escalate your case to an adjudications officer. I would be hesitant to advise somebody to do that. But could you get your TN, or even if you didn't have a TN, could you be in Canada working 2 jobs, one in USA, one in Canada? Sure. I'm just not sure you can do it from USA. Okay.
Okay. The reason I asked is like we are not 100% sure on the CBP decision to allow entry. So we cannot risk our home country jobs at the same time.
Oh, I think waiting until you get the TN entry is fine. Then you can come and resign. No problem.
Okay, that should be acceptable.
Oh, absolutely. Absolutely. No problem at all.
Okay.
All right.
Okay. Thank you.
Good luck, sir. Well, guys, it's time to wrap it up. Good to hear from all of you, and Happy New Year. Merry Christmas. Have a nice vacation, and we'll see each other. I guess we'll talk with each other in a couple of weeks. That should be our regular time anyway. So I'll see you then. Good luck, everyone. Bye-bye.